Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner with Sumner Immigration, and today we are continuing our series of videos on the H-1B visa classification, talking today about the H-1B visa transfer process. The H-1B visa transfer process refers to the process that an employee and H-1B visa holder go through when a person transfers from employer A to employer B. So let's say that you are employer B and you would like to hire foreign national John Smith, who is in valid H-1B status working for employer A. In order to hire John Smith in H-1B status, employer B has to file an H-1B transfer. That means that they have to file an H-1B petition, including all of the elements, the LCA, which is the labor condition application, the required forms, the supporting documents, the support letter, the fees. They file that petition with USCIS. The transfer piece comes into play because we indicate by checking a box or a series of boxes on the H-1B petition to indicate that John Smith is changing from employer A to employer B, still in H-1B status. So what do you need to know if you're filing an H-1B transfer? The first thing is timeline. Keep in mind that we have to include the LCA or labor condition application with the H-1B petition, and it takes Department of Labor up to a week to certify that. So it's going to take a little bit longer than a week from the time we begin the process to the time we're actually able to file the H-1B petition. The second thing to keep in mind is that John Smith, the prospective H-1B employee, can begin working for employer B as soon as USCIS receives the H-1B transfer petition. That's referred to as H-1B portability, and there are certain requirements that have to be met. For example, the prospective employee has to be in valid H-1B status in order for that to apply. But again, you do not have to wait for the petition to be approved before the employee begins working. You just have to wait until USCIS receives the H-1B petition. The other thing that you have to keep in mind, one thing that you have to keep in mind for H-1B transfers is to be aware of the H-1B cap issue. By that, I mean, one of our earlier videos in this series was all about the H-1B cap and H-1B lottery. But if you have a prospective employee who has previously worked only for CAP exempt organizations and your organization is not CAP exempt, that's going to be a problem. So make sure that they have previously been counted against the H-1B cap. And that's not always the case just because they're currently working in valid H-1B status. Next, you have to make sure that your prospective employee is actually working in valid H-1B status in order to file an H-1B transfer. It is possible in some circumstances to file a change of status from some other visa classification to the H-1B if they've previously been counted against the cap, but that's a different process. It's called a change of status, not the H-1B transfer, and the process is slightly different. So what do I mean by valid H-1B status? I mean, first, if they have had previous status violations, if they have previous history of problems with their H-1B status, that will likely follow them to subsequent employers. It's not going to go away just because they change employers. That's something that we screen for and that a qualified immigration attorney should be able to help employers determine before they get too far into the process. Just because a person, I just said they have to be in valid H-1B status, but just because a person is not currently employed does not mean that you cannot file an H-1B transfer. There is something called the H-1B grace period, which refers to a regulation that allows an H-1B employee to file an H-1B transfer or file a change of status within 60 days or until their I-94 expires, whichever is sooner, of their last day of employment. So if you have a prospective employee who's not working right now, perhaps they were laid off, that does not necessarily mean that you cannot file an H-1B transfer petition for them. It's very possible that they could if they're still within that grace period. Finally, you want to make sure how long your prospective employee has left in H-1B status. So remember that H-1B status is valid for up to 6 years total, unless the individual is at a certain point in the employment-based green card process. So if you make an offer to someone who has been in H-1B status for, let's say, 4 years, 5 years, they only have a limited period of time left in H-1B status. And you will probably want to have a conversation both internally and with your candidate about when and if to start the green card process for them. Also keep in mind, it is possible to use a previous green card process. Let's say that they have an I-140 petition approved from a previous employer, either the most recent employer or a previous employer. It is possible to use that I-140 approval to extend beyond the 6th year, even for you, for employer B. So it's something to consider, but it's not the end of the world just because they're towards the end of the 6th year. I hope that you have found this information helpful. Our next video in this series will be on the H-1B extension and amendment process. I promise we'll finish the H-1B series eventually, but there's a lot of information to get through. I hope that you will follow our channel so that you subscribe so that you don't miss the next installment. And until next time, my name is Emily Sumner.